Personnel Administration and another.
Mr. Knox, good morning.
Good morning, my lady. In this matter, I appear together with Mr. Robert Strang on behalf of the defendants Almarales, Stas and Ramhit. My learned friend, Mr. Rowan Pennington-Benton, appears together with Ms. Rambaran for Mr. Smart, and Mr. Stevens, QC, and Ms. Hafsa Masood appear for the respondent.
Yes.
My lords, my lady, you will see this is an appeal against the Court of Appeal's order, and essentially there are two issues. The first is, was the decision which was made by the Commission under Regulation 15 of the Public Service Regulations to advertise to outsiders made lawfully or not? And then secondly, regardless of that, was the decision to disregard the Regulation 18 criteria as between insiders, and I emphasize as between insiders, made unlawfully? Or was it unlawful? My lords, my lady, I shall take the bulk of the appellant's time until about 12:35. Mr. Pennington-Benton has been taken over rather at last minute, although he was indeed junior counsel. So I will be doing the bulk of the arguing.
We were wondering whether the appeal hearing should necessarily take one full day, Mr. Knox. You're all such efficient advocates that we wondered whether we would be finishing this earlier than that.
I'll do what I can, my lords, my lady. Last week I did actually get cut short before I ran out of time, but so I did run out of time.
Well, you won't be cut short before this board, Mr. Knox.
No, when I say that, I ran out of time rather than cut short.
Can you just Knox,
Yes.
the risk of extending what this case is really about? I mean, we all accept that we can't turn back history.
No.
Appointments have happened, and there we are. So it's academic in that sense. But obviously, someone's concerned enough to bring the case to this level after 7 years.
Yes.
What are the real points that people are worried about in practical terms?
Well, I think essentially whether it is lawful to advertise to outsiders without forming an opinion that it is right to do so and that it's in the best interests of the service to do so. The Court of Appeal's decision proceeds on the basis that there has to be something there only has to be something less than an opinion, maybe just considers. So we do say this raises an important point as to when is it appropriate and what process has to be gone through before you decide to advertise to outsiders. That's the Regulation 15 point. We do also say the presumption of regularity point is, we say, quite disturbing as well.
It's not really a presumption of regularity. All that's being said is you have to show that something's gone wrong.
Well, yes, but the way it was applied by the Court of Appeal in this case.
They made rather a meal of that, arguably, with great respect. But I mean, surely the question is you had to show that something's gone wrong. I
accept that, yes. But to answer your lordship's point, was it, as it were, the purpose for future reference? It is, we say, important to ascertain quite what is the test for Regulation 15 for going
You're wanting
outside.
Regulation 15 clarified in that regard, and you're also wanting a ruling on whether or not Regulation 18 plays a role where Regulation 15 is properly invoked.
Indeed, and we say this is important because regulation, I mean, essentially these regulations go back to 1967, 1968, and they are, we say, quite deliberately designed to protect insiders, if I can use that term, and to give a certain degree of certainty as to what's going to happen to them in the future, and that's why you have Regulation 18. I'll come to it later. Right. And we do say it's rather important because essentially what the respondent's case comes down to is this. You can get round all the Regulation 18 protections by advertising to outsiders and getting in, as happened in this case, just 2 outsiders you interview and 9 insiders. And we say, put simply, that can't be right. We're not saying it was done on purpose for that reason, but we say it cannot be right. And essentially, when it comes to the position as between insiders, if you have what you might call these parallel competitions, then you have to decide the position as between insiders under Regulation 18. So, if I can just elaborate, in this particular case, just by way of practical example, what we say should have happened is Petal Rupnerine comes top. She's the outsider, fine. We don't complain about that, subject to the Regulation 15 point. I emphasize subject to that point. But what we do say is, once Petal Rupnerine came top, then the full regulation criteria had to be taken into account in deciding who was to fill the other slot. And it is clear that on the evidence they were ignored, quite deliberately ignored. And we say that is an important point for the future.
Who would that have benefited?
Well, we say if the Regulation 18 criteria had been taken into account, of course, no doubt together with the interview, but on the face of it, the person who would have come top on the Regulation 18 criteria per se would have been either Florence, I've forgotten her name, Ramdeen, Florence Ramdeen or Leslie Almarales. They were the two people in the running. Essentially, they were the two front runners under the Regulation 18 criteria.
Florence Ramdeen was offered second place.
She was.
And turned it down.
And then she turned it down. So we say in practice, of course one's trying to rewind the clock, but in practice what would have happened is that had Regulation 18 criteria been used, then on the face of it, Leslie Almarales would have had a very good shout at being the number, as we're coming second. If the Regulation 15 process hadn't been used at all, in other words, and the competition restricted only to insiders, then we say what would have happened. We say the same in relation to Leslie Almarales. On the face of it, should have come top, or at least second, it wouldn't matter. As far as my other two clients concerned, they were the State 2 solicitor. There were only 4 of them altogether. And so and the top State 1 solicitor. So we say they would have had to have been considered in any event I'll come to the reason why, by the Commission in considering the Regulation 18 criteria. Obviously their case stands on a slightly different footing, I accept that, but in any event, as far as they're concerned, they would have had a chance of being number 2.
They're the ones who failed to spot the notice.
One of them was, I think, on leave at the time. I'm not sure about the other one, but they didn't actually know that the advert...
So you say they'd have to be considered in any event, even though they hadn't applied?
Absolutely. I shall come to the regulation in due course.
Very well.
My Lords, my Lady, what we say, can I just summarise what we say? I've already given a preview, but just what we say for your note on the 2 points. The first point, we say that the Court of Appeal was wrong to say that the Regulation 15 procedure was properly used. And we essentially make 2 points. First, on the findings of fact by the judge and the Court of Appeal, the prerequisite for advertising was not met, to outsiders that is. And I say that for 2 reasons. First, as a matter of law, the Commission has been of the opinion that it is in the best interest to advertise to outsiders, but the courts quite clearly found that only a lower test had to be satisfied and was satisfied. That is to say, that the Commission had to consider it was in the best interests. And the courts below expressly made the point that that was a lower threshold than being of the opinion. We say that was wrong. Secondly, we say that in forming its opinion, or consideration, doesn't really matter, the Commission has to give consideration to the existing pool of staff in order to determine whether one or other limb is satisfied in order to justify going to the outside world. But the courts below made no finding that such consideration was given to the limbs below, nor, in any event, was there any evidence that such consideration, or proper evidence, I'll come to the evidence, no proper evidence that such consideration to the limbs was given. And then we also say on this point, so far as material, the resort to the presumption of regularity in a case such as this is wrong, as the Court of Appeal appeared to resort to it, for 2 reasons. First of all, once leave has been granted for judicial review, there is, I submit, ex hypothesi, no room for such a presumption in relation to the decision under challenge. And secondly, in any event, there was evidence in this case of a lack of proper consideration, that is to say, the respondent's own evidence, which made no reference to any informed decision being made on the relevant criteria. So that's the first thing we say about Regulation 15. The second point we make about Regulation 15 is this. We essentially adopt the judgment of Mr. Justice of Appeal Nareen, and we say that there was positive evidence on the facts that the Commission was improperly influenced to advertise the posts by the Chief Solicitor, and therefore to depart from a pure Regulation 18 procedure. And that was in the 19th and 20th of September 2012 letters. And we say there was, on the face of it, that evidence being completely, and allegations of rubber stamping and so forth, being completely unanswered. The proper inference to draw is that proper consideration to the relevant criteria under Regulation 15 was not given by the Commission. I say that is the proper inference to draw on the evidence, that they did not give proper consideration to the relevant criteria. My Lords, just to repeat, if the Regulation 15 procedure should not have been used, that invalidates the whole process, and with the results that I've already mentioned. Miss Almarales, on the face of it, would have been in pole position, subject to Miss Ramdin, and Miss Das and Miss Ramhit would have had a good chance.
Would I be right in saying, given the passage of time, you don't really need any rulings from us on who is in the pole position and who isn't? What you want is some guidance as to how these regulations are to be applied in future.
Yes, in this type of case, which is not an absurd, it may be a sort of fairly usual case, who knows, depends how much people want to go outside.
Yes, thank you.
On the Regulation 18 point, we say this: as between insiders, regulation must always be used to decide between them. If you have, as here, two vacancies, and you want to look both inside and outside, then you must assess the outsiders as against each other. You don't resort to Regulation 18 for outsiders, obviously. But you must assess the insiders as against each other by reference to the Regulation 18 criteria, as they are mandatory. And you cannot get round that by advertising externally.
And how do you assess the insiders in relation to the outsiders?
Well, my Lords, my Lady, you don't, strictly speaking. What you do is you look at the outsiders and you say, do they justify the reasons for going outside in the first place? Because there has to be good reason to go outside. If they do, on the face of it, that's it. You can take both of them. One can imagine all sorts of different permutations, but I say that's what happens. And then if there is a gap, if, let's say, both fail or one fails, one of the outsiders fails, then you look at the insiders and you say to yourself, right, well, we've got all these insiders. We're now going to have to assess them taking into account the Regulation 18 criteria.
So you're saying that they could take an outsider without considering the merits of an insider's application?
Certainly, if that outsider meets the criteria for going outside in the first place, because the only reason you can advertise outside, well, my Lords, I agree, but the only reason you can advertise to the outside world is because you consider it in the best interest of the service to do so.
You've still got to weigh it all up. There are all these candidates. Some are outside, some are inside, and you've got to choose the best among that whole cohort.
Well, my Lords, I accept that. I do accept that, subject to this reservation. You do have to accept that if you've got a very good outsider, let's say, then you say, I've got the really good outsider I need. Or you might have two very good outsiders, in which case you say, right, well, that's it. Now, assuming for the moment they meet the criteria which justified going outside in the first place, and the point is, you can't just go outside. You have to go outside on the basis in the best interest of the service to do so. And if you say, right, we've got two really good outsiders, then that's that. If you don't, then in my submission, you then you assess the insiders by reference to the Regulation 18 criteria. Now, my Lords, can I just mention one point? That the problem in this case arises because their parallel competitions have been run. Or we say what should have been parallel competitions. What really should happen in this type of situation is you decide to go outside, and then you decide how many people you really need to get from the outside, and then you see if you can get them. If you don't, you then go inside. The problem has arisen in this case because they've run what we say should have been parallel competitions as one competition under Regulation 15.
How do you go back inside again?
Yes.
Because the whole point about Regulation 15 on your analysis of it is you only go outside if inside can't meet the need.
Well, or at least they can, but you would think it would still be better to go outside. Sorry, but my lady, what would happen is you'd go outside in the first instance, let's say you've got 2 vacancies. And you say, I think it's best to get 2 new people from the outside, having considered everything. You would then look at the outside and you would assess at that point whether the people you've got meet the criteria or meet the reasons for going outside in the first place. So, for instance, if you've got a lot of construction work coming up, or whatever, or you've just lost a construction lawyer, then you might say, really, we need to get someone from the outside world on this because we've got a lot of big work coming up. You then look outside to see if you can get the sort of person you're looking for, which you think can only come from the outside, or best come from the outside. If you get them, fine, that's the end of it. If you don't, then you're left in a position where you say, right, well, we've gone outside, we've only found 1 good person, we've got 1 vacancy left, we'll have to resort to the insiders.
Your interpretation of 18 really flows from your interpretation of 15.
Yes.
Namely that you have to have rejected in your consideration of the inside candidates, rejected the insiders before you go out.
Yes,
rejected. If that is wrong, if there is a less of a hurdle to get over, then your approach would have the effect that when you do advertise for a post, you would be cutting out the insiders, saying, well, outsiders get a free run at it until we've deemed them to be unsuitable, and only then does the insider get a look in.
Well,
I think that is the effect of the parallel system.
It is the effect of my submission. But the point being, you don't just go outside. That's the essence of it. You can't just run outsiders. You can't just go to the outside world in the first instance. You have to be satisfied that the existing pool of candidates doesn't give you what you want. Even if they might be suitable, they're not quite the sort of standard you're looking for. They don't have the particular qualities you're looking for. That, in my submission, is the way the regulations work. I'll come later, but I can sense a degree of scepticism about it, but in any event, provisional scepticism, but I do submit the point about regulation 8 can't just be sidestepped by going to the outside world, and that is an important point. And I take your lordship's point. How does this play out in an extreme case? Can I just mention this, though, for your note? There's no suggestion in this case that Florence Ramdin or Priscilla Rampersad, the insiders who came 2nd and 3rd, there's no suggestion in this case that somehow they were much better than sorry, there's no suggestion in this case that they would have come top. I mean, what we have in this case is a clear case of the outsider coming top, the other outsider being rejected, and therefore the question is, how were the insiders to be assessed? So, my lords, my lady, although I can see, as I was discussing with Mr. Strang yesterday, as you can imagine, well, you can imagine all sorts of permutations. On the face of it, in a case like this, the problem doesn't really arise. And so I submit that's the important point to hold on to in this case.
Well, it may be that it assists your submission, but in any given situation, that might well arise that you'd have a close competition between insiders and outsiders. And I'm at the moment having difficulty in understanding what criteria should be applied in judging an insider against an outsider.
Yes, well, well, there's no doubt what criteria should be applied as between the insiders. The question then arises, supposing you're comparing an insider against an outsider. On the face of it, there are no particular criteria. And in one sense, that's the problem.
Shouldn't all the candidates in the competition be assessed by the same criteria?
Well, if they are to be, the only criteria that exist are the Regulation 18 criteria.
They're not appropriate for someone who's outside.
Not as between outsiders, certainly. What do you do? The problem's easy if the outsiders are the best anyway. Or the real problem comes in supposing you suddenly think to yourself, well, I thought I was going to get some really good outsiders. What's happened is I've looked inside and I've got someone who's absolutely fantastic. What happens then? Yes. Now, that isn't the evidence in this case. I think, my lords, that's my fundamental submission, but I do accept there could be a problem in that case.
We have to consider how
yes.
the system could operate in those circumstances,
yes.
if you're right in your submission.
Yes. Well, my lord, can I deal with that later? Because I'm anxious about time. My Lords, what I propose to do is first I'll just briefly mention the legal background without arguing. I just want to show you the relevant regulations. And then I want to take you through some of the chronology just to identify the relevant documents that were created before proceedings began. Then I want to explain what happened in the proceedings, and that is important on the question of the presumption of regularity and, as we say, the improper conduct by the Commission, or at least inference of improper conduct. And then I'd like to turn to the arguments as to why the Court of Appeal was wrong, first on Regulation 15, then on Regulation 18, and then briefly deal with the question of relief. My Lords, can I just deal first with the structure of the service, just so you can see how this all works. If you go to the authorities bundle at tab 18, at 1928, you have the Judicial and Legal Services Act, and Derek.
Page?
1928, it begins at 1928, but the relevant provision to start with is section 3, which is at 1929. Which establishes the service, and then subsection 2, the public offices and the public service set out in the first and second schedules shall be deemed to constitute the judicial and legal service. And then you go to 1935, which is the first schedule, legal offices, part 1, civil law department. And you see here a list, the hierarchy. And you'll see about halfway, a third of the way down, the chief state solicitor, who is the head of department. And then a few down, senior state solicitor, which was the job being applied for, and then state solicitor 2, which is what my clients were, save for Miss Ramhit, who was state solicitor 1. And that's the format. My Lords, if you wanted, I don't propose to go to it, but at page, bundle 4, page 1254, there's a table which sets the matter out in more detail as to how the judicial and legal service works.
Page?
1254, there's a table. As at December 2012, when the advertisements were placed, there were 4 people holding the post of State Solicitor 2, just 4. We give the references at paragraph 34 of our case, E1505. That is to say, Almarales, Das, and Smart, and Florence Ramdin. They were the 4 State 2 solicitors, and therefore, on the face of it, in line for promotion to State Solicitor, Senior State Solicitor. Miss Ramhit was the most senior State Solicitor 1. And the reference is 3/1152/18. My Lords, going now to the regulations, these are found at tab 17 of the authorities bundle. These are found at tab 19. My Lords, they were passed pursuant to section 127 of the Constitution, or what is now section 127 of the Constitution, and adopted by the Judicial and Legal Services Commission in 1984. And tab 19, if I can just ask you to start at Regulation 7, 1955. Regulations 5 and 6 have provide for how meetings are to take place, either in person or by distribution of memoranda. And then Regulation 7, the Director shall ensure that minutes of all meetings of the Commission and of all decisions arrived at shall be duly recorded and kept, and that the same be presented for confirmation as soon as practical, and so forth.
Now, the Director is the management arm of the Public Service Commission.
Yes, she's the Director of Public Administration. Of personnel. So she is to ensure that minutes are kept of all decisions. I'll explain the relevance of this later. And then Regulation 8 provides that the Commission can consult with other public officers as desirable. And then going over to Regulation 13.1, my Lords, of some importance in the context of this case. As soon as it is known that a vacancy will occur, the Permanent Secretary or Head of Department shall communicate to the Director in writing, and then, importantly, shall make his recommendations regarding the filling of the vacancy. So there's no doubt that in this case, the Chief Solicitor, for instance, Chief State Solicitor, could make recommendations to the Director. That much we accept. But I'll explain why we say he went far further than that in due course. Subsection 4, my Lords, is the point which I mentioned earlier on in answer to your Lordship's questions, namely that even if a circular memorandum is put out internally for promotions or vacancies for promotions, then nonetheless all claims of eligible public officers have to be considered. And you get that from the tail end of 13.4. And then 14, whenever, and I emphasize these words, in the opinion of the Commission, it is possible to do so, and in the best interest of a particular service, within the public service, appointments shall be made from within the particular service by competition, subject to any regulations limiting the number of appointments.
In 13.4, when it says consideration of the claims of all eligible public officers, are you saying they have to be considered whether or not they actually make an application?
Yes, my Lords, yes.
Right?
You consider it in any
Well, no, the
event.
claims, it rather assumes they made a claim, doesn't it? I mean, if someone hasn't said, I want to be appointed.
Well, but it says the failure to apply shall not prejudice the consideration of the claims. So that rather suggests, let's say in this case, Ms. Das failed to apply because she's on leave, so she doesn't know about it. Still, you have to consider her such claim as she has to being appointed. It's presupposing a failure to apply, but nonetheless you have to consider the claims of others.
Well, how does one assess someone's claim to a post without them putting their best foot forward?
Oh, by looking at their personnel records. So there could be recommendations in any event under 13.1.
But if you're
So
right on
you
that,
look at the personnel records?
Oh, most certainly, under Regulation 18. Oh, yes, and so forth. Oh, yes.
but if you're right on that, there was a clear failure in this case.
Yes. Yes. We say under Regulation 18.
I hadn't understood that to be put on 13.4. Maybe I
Well,
missed it.
we're not. That's because the Regulation 18 procedure simply wasn't used.
I see. So you're not suggesting that 13.4 operates separately from Regulation 18?
No. We say that is to be read with Regulation 18.
Yes.
No doubt, of course, it comes into, I mean, in Regulation 14, we do say, and I think I got to Regulation 14, you have to consider what's in the best interests of the public service, and so forth. But then Regulation 15...
Is there any value in our comparing the opening words of 14 and 15, Mr. Knox?
Well, we say...
Whenever in the opinion of the Commission, contrast with where the Commission considers.
We say that the two have to be read together, and what it is saying is, in other words, of the opinion. And we say considers you can't read considers in isolation from of the opinion in 14.
You're not saying they mean something different, are you?
I'm saying they mean the same.
Yeah.
Exactly.
Of the opinion considers
Yes.
identical.
But that's the threshold, and it's presupposing, because the phrasing of the opinion is being used in 14, then considers is perhaps a loose expression, but obviously being used in the same sense as of the opinion. Because this is a single process. And it considers either, and my lords, my lady, we accept there are two limbs, either there's no suitable candidate already in the particular service available for the filling of a vacancy. You'll note the reference to particular service picking up Regulation 14. All that, having regard to qualifications, experience and merit, it would be advantageous and in the best interest of the particular service that the services of a person not already in that service be secured. The Commission may authorise the advertisement of such vacancy. my lords, we do say that one or other limb has to be satisfied before going outside. And in this case, the relevant limb, by all accounts, was the second limb, namely, having regard to qualifications, experience and merit, it would be advantageous. So what we say in summary is, well, there had to be consideration at the very least of the qualifications, experience and merit of the insiders before going outside. And that makes sense, because the default position in 14 is that you stay inside whenever, in the opinion of the Commission, it is possible to do so. So you start on the inside and then you say to yourself, are they any good? And if so, how good? And then you still say, there may be circumstances where you say, we need to go outside. And there are all sorts of examples which one can come up with, which make perfect sense. For instance, the one I mentioned earlier, supposing you have a lot of building work coming up in the next 10 years, you need experienced building solicitors, you've just lost the one person who was best at doing that. You might say, let's go outside, because we really do need to get someone with commercial experience on the outside world. Things like that. We say that's what it's designed to do. It's not designed as a sort of general, all-purpose, you can go outside whenever you feel like it.
Would that be a matter for the Commission to decide for itself, or could they act on the say-so of the Chief Solicitor?
They would have to decide it for themselves. Of course, they can take into account his views, but they can't just, it's a phrase that's been used in the cases, they can't just rubber stamp them. They have to give independent consideration to whether his views are correct or not. Now, normally, that might be a simple matter. But in this case, we say, well, he seems to have given a number of different views as to why it's a good idea to go outside. And we say that's why it's not so straightforward in this case at all. Because he's put all sorts of different views forward. And we do say, in that circumstance, the Commission has to turn its mind to what is actually the position. We do also say this. When you look at the evidence, there's not a shred of evidence that the merits of the individual candidates were put before the Commission to consider. Internal candidates. None. I'll come to this when I take...
This is at the stage of deciding whether to go outside.
Yes, exactly. At that stage, just nothing. And you'll note, may authorise, it's discretionary, even then, it's for the Commission to decide. And then you have Regulation 18. I don't think 16 and 17 take one very far. Regulation 18, in considering the eligibility of officers for promotion, the Commission shall take into account seniority, experience, educational qualifications, merit and ability, together with the relative efficiency of such officers, and in the event of an equality of efficiency of two or more officers shall give consideration to the relative seniority of the officers available for promotion to the vacancy. And then 2, the Commission, in considering the eligibility of officers under sub-regulation 1 for an appointment on promotion, shall attach greater weight to seniority, where promotion is to an office that involves work of a routine nature, or B, merit and ability, where promotion is to an office that involves work of progressively greater and higher responsibility and initiative, and so on.
Going back to 1, why is, in the event of an equality, limited to efficiency? Why isn't it an equality referable to the whole gamut of factors that had been identified in the earlier part of the sentence?
Well, I suppose because efficiency is taken, my lords, is the most important thing.
Well, surely it ties in with 2A, that
yes.
give weight to it where it's a routine work, where
Yes.
efficiency is probably an important criterion.
Yes. My lords, one can... These regulations have caused problems in the past. But one can see the general drift of what
Very
we're
well,
driving.
yeah, let's go on.
But the important points, really, as far as this case is concerned, is subparagraph 3. In the performance of its functions under sub-regulations 1 and 2, the Commission shall take account as respects each officer. So this is what's got to be put before the Commission, we say, under Regulation 18. A, B, C, special qualification, D, special courses of training, but importantly, E, And we say, and this was really the beef which the appellants had in the affidavits, the evaluation of his overall performance is reflected in annual staff reports by the permanent secretary, head of department, or other senior officer for whom he's worked. Letters of commendation and any specific recommendation. So this, we say under the Regulation 18 criteria, you can have interviews, we don't doubt that, but those interviews are assessed taking all this into account. Now, in this case, there's no evidence that any of these things were taken into account on the interviews. We just don't know.
There's no evidence they weren't. I mean, it's for you to show they weren't.
My lords, I respectfully submit no, because they disavowed entirely the notion they'd applied the Regulation 18.
18 doesn't come into it at all.
And I will come to a reference where it suggests that what happened is they just looked at the interviews. How well have you done in the interview?
Yeah.
Yes, there was an interview and then a list of merit based on the interview. Was that?
Yes, it's based purely on the interview.
Yes. Yeah. Was this a case where the work was of a routine nature?
Well, I don't think it's fair to say that there was any evidence of that either way. I would have thought the appellants would say not.
I was wondering.
Exactly. Rarely seniority doesn't come into it, does it?
Well, it might do as between, I'll come to that in a minute, because it might do as between an equality of efficiency.
Yes, but efficiency would probably, for a rank of this seniority, then you'd expect you weren't addressing, you weren't assuming that it was work of a routine nature. Therefore, the criterion would be efficiency.
Yes.
If there was an equality of efficiency, then Regulation 18 has as a tiebreaker seniority.
Yes, exactly. And indeed, I'll come to it.
Well, except that, as I read 18.2, it's only where it's a routine nature that seniority is a tiebreaker.
Well, I think 18.1 I would suggest
18.1 makes it the tiebreaker.
Is also, as it were, the tiebreaker point.
Well, I wonder about that. Anyway.
I mean, 18.2 simply is a weight provision. 18.1 has a tie-break provision.
Is that right? Anyway, never mind. They didn't consider Regulation 18, so that's it.
No, I will, this is important to look at a bit of earlier correspondence where they were considering it, to see just how they were going to apply it. Because at one point they were going to go down the Regulation 18 route. Can I just make a point? There's no doubt that in Regulation 18, eligibility means suitability rather than eligibility to be considered. It means suitability.
That's Lord Mance, isn't it?
That's Lord Mance and Sankar. My Lords, one other point I do want to emphasise, we refer to in our case, and that is Endell Thomas. These regulations are passed under the Constitution, and the whole point of having independent service commissions is to prevent improper influence, or influence, whether improper or otherwise, by the executive on the commission. And the passage is in Authorities Bundle, page 1632 at 1643. So it is not a sort of mere quibble to say, as we do, well, what on earth did the Chief Solicitor think he was doing by writing to the Attorney General to say, please use your good officers to talk to the Chief Justice on that panel? We say that's completely out of order, out of bounds, and not what you're allowed to do under the Regulation 13.1, which I showed you, which is to make recommendations to the Director of Personnel Administration. We do say it's an important part of the background to how you assess the allegations we make in this case. My Lords, can I just take you to some documents? There's a chronology which we attached to our case. My Lords, I'm not going to take you through all of it, but I would just like to run through some points in that chronology, which, needless to say, I appear to have lost at the right moment. It's attached as an appendix to our case and begins at 1522 in the electronic bundle. And one can pick it up on page 1522 with the letter of the 25th of July 2012. And can I take you to that letter? It's at page bundle 4, 1279. Which has got rather a bad copy, but I'm told by Mr. Strang we've got a good copy now. Which I gather has been handed up, yes. So it may be better to as it were, have that beside the bundle as well, at 1279. Now, at this point, this is 25th of July 2012, there is just one vacancy for state solicitor, senior state solicitor, and this memorandum is a memorandum from the Chief State Solicitor to the Director of Personnel Administration, and he recites the qualifications in the second paragraph of Mrs. Almarales, and then in the third paragraph of Miss Florence Ramdin. And you'll see they're both State Solicitor too. And you'll see there's just one vacant office. Third paragraph down, I believe the fairest resolution of this issue would be if, in accordance with Regulation 14, you interview both Miss Leslie Almarales, State Solicitor 2, and Miss Florence Ramdin, State Solicitor 2, to fill the vacant office of Senior State Solicitor. Thus, the one who tops the interview process, the competition as envisaged by Regulation 14, should be the one promoted on merit. Then at 1280, you've got a bad copy, but we now have a good copy. The option to interview Mrs. Leslie Almarales and Ms. Florence Ramdin for the position of Senior State Solicitor will afford them an equal opportunity at the position, since their claims are on the ground of seniority and experience, respectively. So at this point, essentially, the Chief State Solicitor is making his recommendation, and he's saying, I can't really decide, so I'm not going to choose between them. Why don't you interview them? You'll note in the second paragraph, just going back to 1279, that the reference to the litigation schedule being seriously challenged for staff, but she is on the litigation schedule. My Lords, the reason I emphasise that is because one of the complaints my clients made is Ms. Rupenarine had no litigation experience at all. She was a conveyancer and commercial person. So that's the letter. And so this is obviously not known about, I should say, to Mrs. Almarales. She has no idea about this at the time. The next thing that happens, as far as we know, is on the 19th of September, 1296, in the same bundle. And this is the letter from Miss Rupenarine to the Chief State Solicitor of the 19th of September. And you'll see what her practice is from the first paragraph. It's conveyancing and commercial contract work. She refers to some work she's done, complex transactions. In the second paragraph, it's my fervent wish to be treated fairly and on the same basis as my peers in the department, and to be a permanent part of your team. I therefore sincerely ask for your assistance to validate my work. I'm aware there's a vacant established post of Senior State Solicitor and so forth. I've been advised and informed by the DPA that I can only be considered for interview when the post is advertised. I'm uncertain, however, whether the current or upcoming vacant post will in fact be advertised. So please could you give them the necessary recommendation. Then over the page, this is the letter of the Chief State Solicitor to, you'll note the first thing is it's to the Attorney General. First paragraph he writes...
So that's his boss, really, isn't it?
That's his boss, yes. And you'll note, my Lords, it's copied to the Director of Public Administration on 1298. He encloses, at the end of the first paragraph, the letter I've just shown you from Miss Rupenarine. And then in the next second paragraph, going over the page, he describes the work she has done and saying how good she is, essentially contracting conveyancing work. He goes on, next paragraph in 1298, to say how good her resume is, and it's superior to the present incumbents of the Senior State Solicitor's post on the establishment. And says that's what she'd like to be considered for. And then the final sentence of that paragraph I firmly believe that this unusual sacrifice should be eagerly embraced by the state, and everything, I emphasise, and everything be done to assist Miss Rupnerine in her quest to come under the establishment. It's in these circumstances, therefore, that I'm requesting that you use your good offices to ensure by communication with the Chief Justice that the vacancy of the post that currently exists be urgently advertised so the process of interview can commence.
Now, you want to tell us what was wrong with that letter?
Yes.
But now or later?
I'll tell you right now. What I say is wrong. First of all, it is what the Chief State Solicitor is entitled to do is to make a recommendation to the Director of Public, to the Director of Public Administration. That's all right. That's under Rule 13.1. That's what he can do.
And he's entitled to make a recommendation, and the obvious recommendation would be that the post be advertised.
Entitled to make a recommendation, yes.
Yes, that's the only thing that he can do if he wants her to come in, to give her a chance, is that to recommend that it be advertised. Yes.
What I submit is wrong. First of all, he is not directing this solely to the Director of Public Administration. He's writing to the executive and basically saying, could you...
No, I mean, I understand that. I'm trying to get what he could have done properly.
Oh, yes.
To recommend. And obviously you're going to explain to us what difference it made that he wrote the letter to the Attorney General rather than just to the DPA.
Well, if he's entitled to make a recommendation, not an exhortation. He's entitled to do what you might... He's in a position of the head of the department. It's his role to assess impartially the various candidates and so forth.
I understand all that,
Yeah.
but what matters is what difference does it make to the result?
Well,
There's no suggestion that the Commission were unduly influenced by this, as far as I know.
Well, no, my lords, there is a suggestion that they were, but we're not saying in the final result, but we do say that this, on the face of it, this did influence their decision to advertise in this respect, because they were focused only on one thing, namely getting Miss Rupnerine in. They did not consider the matters which needed to be considered, namely the qualifications and so forth of existing staff. And whether, weighing everything in the balance, weighing that in particular in the balance, they should indeed go outside. So
under 13, it's not for the Chief State Solicitor directly to make a recommendation to the Director. It's the Permanent Secretary or Head of Department to do so.
Yes.
So in those circumstances, what is wrong with his channeling his recommendation to his boss for onward transmission?
My lord, I think in this case the Chief State Solicitor was the head of department.
Yes.
He is the head of department.
Is he?
Yes, my lord, yes. I mean, when you say the Attorney General's his boss, the Attorney General is a member of the executive, but only in that sense his boss. So, my lord, I do submit it is wrong for him to write to the Attorney General. And I submit this letter, and it's wrong.
It's wrong for him to tell his boss
Yes, what he can do
what
is write...
he proposes?
No, what he can do is write to the Director of Public Administration straight, saying, these are my recommendations. That's it.
But he could copy his recommendation to his boss, but what you say he cannot do is request that a member of the executive use the good office
Yes.
to ensure that the Commission does something.
Yeah.
It's actually to ensure that the Chief Justice something does.
Well, Chief Justice on the
Slightly
Commission. I mean, my lord, that's what we say is objection. It's essentially...
odd, I must say, but
My lords, of course, my lords, I take your lordship's point. In one sense, one says, what is wrong with this? On the other hand, can I put it this way? Anyone seeing this letter who was part of, or thought they were in the same competition, would think, no wonder I lost. Well, no wonder it was advertised. It does certainly give the appearance that personalised, what you might call influence, is being requested.
Now the judge at first instance criticised
Yes.
this letter, and I don't think the Court of Appeal disagreed with that criticism.
I'm not sure. I think the majority may have said they didn't see there was anything...
Well, they didn't see any impropriety, but,
Yes.
I don't recall that they supported the head of department writing to the Attorney General in these terms.
Didn't they say, if it can be criticised at all, the criticism is that it was overly enthusiastic?
Well, my lord, that is certainly a criticism.
Isn't that what they
Yes,
said?
by the way, I can't, to be honest, my lord, I cannot directly
You can't?
recall. But this is the majority.
Yes, of course.
Yes, I think, my lord, that it certainly rings a bell, my lord. I cannot off the top of my head recall.
Thank you.
Forgive me. We say there are a number of criticisms that can be made of it. And it's the exhortation, this isn't the recommendation. Yes, my lords, everything be done. If you say to the taxi driver, which was a bit late for an appointment, could you do everything to get there on time? That is a sort of, well, you know.
Yes, I mean, if we're concerned to give guidance for the future, we should suggest that this may not be the best way to do it.
No.
That's accepted.
But anyway, you're addressed to the wrong person. That's one thing wrong. Secondly, the tenor of it is an exhortation, not a recommendation. And thirdly, it's use your personal influence. It's suggesting you go through what you might call private channels rather than the usual public channels.
Yes?
My lords, just going back to the chronology, if I may, if one moves on now to the 25th of October, over the page at 4:12:99, you can see a memorandum from the Chief State Solicitor to the DPA of the 25th of October, and you'll now see that there are offices, plural, at 12:99, so by now there are 2 offices. And he refers to the 20th of September memorandum. It's not quite clear what other memorandum he's referring to, but also to the 25th of July. So he's referring back at least to the 2 notes we've seen, and maybe one other, it's not totally clear. As requested in my memorandum, and in accordance with Regulation 14 and 15, my request to have the 2 posts of Senior State Solicitor advertised still stands. So that appears to be i.e., as in his 20th of September letter. And then on the same day, he writes to the, next day, 26th, over the page, 1300, he writes to the Permanent Secretary of the Attorney General, attaching his memorandum. One takes it, the memorandum at 12:99, for information, asking it to be forwarded to the DPA as a matter of urgency. And then over the page, 1301, you can see the Permanent Secretary of the Ministry of the Attorney General writing to the DPA, again on the 26th, about the advertisement of the vacant office, or vacant office, singular now. He notes there currently exists 2 vacant posts in the second paragraph due to certain promotions. And then he adds this: over the years, the Chief State Solicitor's Department has been faced with a severe shortage of experienced attorneys at law at mid-management level due to a rapid turnover of staff at this level. In an effort to attract attorneys at law with considerable legal experience, practice, knowledge and expertise to the department, and capable of filling these 2 vacant positions of Senior State Solicitor, the Chief State Solicitor is of the view that it is in the best interest of the department that these positions be advertised, and thus such a recommendation was made. Then he recites Regulation 15, and then he adds, in the circumstances, I'm requesting that the 2 positions be advertised as a matter of urgency to address the current staff shortage. Now, my lords, you might say, that would be all right. Which we say, yes, and that was indeed what we were being told for a very long time, was the position. But it is, on the face of it, completely the opposite of what was said in the 25th of September letter. 20th of September letter, made no mention of staff shortages or anything like that. It's just, we want to get Miss Petal-Bruckner in. And indeed, the 25th of July memorandum, which said, it's between Miss Almarales and Miss Ramsden, make up your mind. So, my lord, the reason I emphasise this, my lord, I just want to make this plain. We're not saying that there was bad faith or bias, but we are saying that there are grounds, very serious grounds for concern, which make any resort to the presumption of regularity wholly inappropriate.
But I mean, what are you saying? You're saying that this in itself is all right,
Well,
I'm
that would
not
be...
suggesting bad faith.
No, I'm not saying that... I'm not...
So
you
if
can't-
this was the opinion, as you accept,
Well-
at that time in December, in October 12th...
Well, my lord, we say we
what's wrong
don't...
with it?
Well, my lord, we say there's no evidence either way. The problem...
There's this being written.
We've got two things being
You must
written.
take it as having been written by someone who believed it.
But yes, the trouble is this is all based on the information from the Chief State Solicitor. And we have
Well,
no...
I wonder. I mean, here, this is the permanent secretary to in the Ministry of the Attorney General. So why would the Attorney General, and in particular the permanent secretary, not be aware that, over the years, the Chief State Solicitor's Department has been faced with a severe shortage of experienced attorneys at law?
Well, my lords, that may be. I accept on its own. The difficulty is this information appears to be emanating as well from the Chief State Solicitor. And there is no evidence from the Chief... The real problem is this, my lord. Later on, when allegations were made about rubber stamping and so on and so forth, absolutely no evidence came in from the Chief State Solicitor to explain, or indeed the Commission, to explain what their thinking was on this. So the point is left totally unexplained.
It's not. They're saying we need more solicitors.
But what's the real reason? And my lord,
Well, unless you can cross-examine someone and show bad faith, you're stuck with what they said.
well, my lord, not everyone's talking about the presumption of regularity.
You need the presumption of regularity if you've got material in the correspondence establishing a need for a particular expertise in the department.
Well, my lords, of course, my learned friend might say he doesn't need the presumption of regularity. But I say the Court of Appeal did rely on it, and that's why we want to knock it out. We say you can't rely on the
Well,
presumption.
4 times so far in your excellent submissions you have referred to this. You mustn't treat it too much as an Aunt Sally, Mr. Knox. And my respectful advice would be not to spend too much time on the presumption, notwithstanding that it was mentioned in the Court of Appeal.
My lord, so be it. We do also make this point. We do say there are grounds for saying that the decision, as I mentioned in my opening, that the decision to advertise was tainted by improper considerations because they did not turn their minds to the existing pool of staff. And my lords, what one gets...
That's the legal argument based
Yes.
on interpreting the regulation.
Yes. And what I say one does get out of both the letter of the 20th of September 2012, urging Petal's merits, essentially, please go outside, and also the letter you've just seen, is that there is no reference at all to the merits or otherwise of the existing staff. Now, my lords, you say there is reference to the shortage of staff. I accept that. But it doesn't follow that because there's a shortage of staff at mid-level, that therefore what you do is you bring in someone, you advertise at state senior solicitor level rather than at state solicitor 2 level, and so on and so forth. It's not a complete answer. There are all sorts of levels you can bring people in at, not just senior state solicitor. And so it doesn't answer that point. And that's why we say it's so important. You have to consider how good the people you've got are. And there's no suggestion in that evidence that they are doing that.
Well, the memorandum of July the 25th was in front of them.
Of the...
July the 25th. Oh, 1233.
Yes. Well, yes, it was in front of them, yes. But subject to that, they haven't given overall, on the face of it, the difficulty is we don't quite know what consideration they gave. I'm going to have to come to the evidence briefly as to what consideration they did give. But they would have had that.
There's a finding in the Court of Appeal that in the normal course of things that both 1926 and 1927 to 1928, the letters of September would be before with the Commission, I think.
Yes.
Yes, reversing the inference that the trial judge made.
Yes, yes. So one can assume that these documents were in front of the Commission. My Lord, just going to the chronology, but I'll just come to 1 or 2 documents. Just going back to page 2, 16th of November, the Permanent Secretary it chases up for an answer. I think he's writing to the DPA. What's essentially...
What letter are we on?
Page 2, 16th of November 2012. So it's just a reminder, we want them advertised. The
What's
advertisement...
the number in our bundle?
Oh, it's page 1523, forgive me, my lord. So there's a chaser, essentially, by the Attorney General to the DPA to advertise.
1523.
1523, at the foot of the page, 16 November.
Don't think I do.
It's said to be 1303, and there is a memorandum on 1303.
Yes. Oh, there is, yes, yes.
It's not that
1303.
1303, yes. It is. Sorry, I didn't want to go to it. I just wanted to, because it doesn't say very much. I just wanted to give the context.
But it's nothing to do with 1523 then?
1523 is the chronology.
Sorry, it's page 1523.
You don't have a 1523.
Oh,
We do, it's the chronology.
It's the chronology.
Yes, we're there. We're with you. Thank you.
I think chronology page 1524, if you have numbers.
Yes.
On the 10th, just so you can see the sequence, on the 10th of December you have the internal memorandum. And then on the 17th of December you have the external advert. And then also on the 7th of January 2013. And then on the 25th of February, Mr. Smart and other state solicitors write complaining about the decision to advertise to the world at large. And, my lords, it's important, can I just ask you to look at this letter? It's at 1319, because his evidence of this was that he showed, and his and Miss Almarales' evidence of this was that he showed it to the chief solicitor, chief state solicitor. And if you go to 1319, you'll see it records at the top, UFS Chief State Solicitor, under first signature, Chief State Solicitor. Now, my lords, just dealing with this briefly, the defendants denied that the Chief State Solicitor signed this document, but they did not deny the allegation that he had read it. And you'll note, this is a complaint from Mr. Smart and other signatories at the foot of the, I think, 1324, including my clients. Certainly Ms. Almarales says she signed it. It's a complaint about the fact that the advertisement appears to have gone to the outside world. And what I particularly want to draw your attention to is at 1321, the third paragraph down. In this circumstance, we say it was simply unfair and unjust to advertise the subject post to the world at large without first giving careful consideration to the qualified establishment officers. In our view, the organisational structure was unreasonably unfairly disregarded, as the post of senior state solicitor is not an entry-level position per se. And then, importantly, on or around mid-December 2012, when inquiries were made to the head of department, he indicated that he knew nothing of the decision to advertise the post to the world at large. Thus, it was apparently done without the recommendation of the Chief State Solicitor, yet the Director of Personal has invited persons to apply. So, the position as far as Mr. Smart and the other applicants is that the Chief State Solicitor is denying any knowledge of what's going on. Although it is exactly at his instigation it's all happened. That's the picture being presented to them. In our chronology, we give certain references under the heading 25th of February 2013. Can I just ask you to note the bundle 3, page 1027, at paragraph 20, the defendant's evidence denies that that this letter was signed by the Chief State Solicitor, but doesn't deny the allegation that he had read it. My Lords, I should say the defendants didn't disclose a copy either of this document. My Lords, going over the page in the chronology, 1525, the 21st of June 2013, the interview process takes place. There's some confusion as to whether it was 9 or 7. It doesn't matter. but the evidence from the defendant was 11 people attended, 2 outsiders and 9 insiders. And then, my lords, you'll note, if I can just ask you to add this, there's a reference from a response by the respondents to a pre-action protocol correspondence at 1467, when they say that of the 11 candidates interviewed, only 3 candidates were successful at the interview, and an order of merit list was established.
What date do we put on that?
Well, that was, put that as a number, as an addition to 21st of June,
Oh, very well.
2013.
Very well.
Because that is what the defendants themselves later said in a pre-action protocol response at 1467. So
Yes.
it basically just an interview appears to have been carried out. My lords, going back to the chronology, neither the appellants nor Mr. Smart appear to have been told the outcome of the interviews, but on the 7th of October, Mr. Smart finds out that an outsider has been appointed, and so on the 4th of November he writes a pre-action protocol letter complaining, and then importantly, on the 13th of December he makes a freedom of information request, which includes in particular letters, memoranda of recommendation by the Chief State Solicitor. So it goes back to then. He applies for leave on the 6th of January 2014. And then on the 18th of February, after being given leave, this is over the page now, he applies for judicial review, seeking various declarations and so forth. Now, my lords, can I make this point candidly right up front? I accept that the precise way the applications put in the judicial review applications of both Mr. Smart and my clients was not specifically the way I'm now putting the case. Essentially, they were making attacks to the effect that, well, you shouldn't have used regulation, you shouldn't have gone to the outside world in the first place, because there were lots of good insiders. It wasn't put legally quite the way I'm putting it. And secondly, the Regulation 18 procedure had to be used. That was the essence of it. But they weren't, I accept, putting the case exactly the way we put it. But what happened is, in the defence, if I can call it that, on the Regulation 15 point, I'll come to it, what is said is that the Commission gave consideration to the relevant criteria under Regulation 15, but without any elaboration. And in relation to the Regulation 18 point, they said, we didn't consider Regulation 18 at all, full stop. And so really our case is not so much built on the original allegation, but on the defence to the allegation, saying, well, if that's right, you didn't give proper consideration.
Yeah, I mean, that's a clear-cut point of law. They didn't give consideration. Exactly. If they were required to, then there was a failure.
Yes, but I just want, because my learned friend quite rightly takes the point, well, this is not exactly how the case was put initially, to which we say, quite true, but it is essentially based on the defendant's own evidence and their own stance. My lords, just going back to the chronology, on the 18th of February, Mr. Smart formally applies for judicial review, now having been given leave, and he then applies for interim relief on the 26th of February. And it's important, my lords, just to see what happened on that, because on the 21st of March, the DPA put in an affidavit opposing that application and said some important things. And the best version we have, although we've got a rather difficult to read version at 13, I think it is, it's bundle 3, at bundle 3, 996. My lord, can I just take you to one or two bits of that affidavit? First of all, paragraph 4. It's a rather bad copy. We've got a better copy in the supplementary record at 1975. It's pretty...
996 doesn't have a 4. You mean 998, do you, Mr. Knox?
Yeah, forgive me, my lords. I've jumped from between different bundles.
You should have a very slim supplemental bundle which has got that and nothing else in it. It's a very clear copy, so
Good.
it
Yes.
might be easier to look at.
Yes.
I'm sure it would be.
Thank you.
This is what, the affidavit in reply?
Yes, we've got a bad affidavit in reply to the application for interim relief. We have a bad copy at 996, but we have a good copy now in the supplementary record at 1975.
73.
Oh, 3 on paper, 5 electronically. I'm told it's 1973 on paper, 1975 electronically.
Hold on, please.
And, my lords, just 2 things to note. The first is paragraphs 4 and 5 disclose for the first time the existence of the 26th of October memoranda, which I showed you earlier.
I'm sorry, I'm lost.
Forgive me.
There's a document we've got now. Is that,
We've got a clear copy of what I took you to.
Supplementary record.
have I got there?
Yeah.
Oh, there. Is that it?
My lords, forgive me, I'm only going to this because the first one is virtually impossible to read.
Look,
There's a spare one.
looks like that. Too late, because I used it on the computer.
Oh, here we are. Right, sorry, with you. What page?
It begins at 19, on the hard copy, 1973.
Yeah.
And just 2 points. First, this is the first time the 2 documents are mentioned in paragraphs 4 and 5, the documents being the 26th of October memoranda, which I showed you earlier, which attached the 25th of October. That's paragraphs 4 and 5.
So are you making a point that these ought to have emerged earlier?
Oh, most certainly. But, my lords, I'll explain later, but one can just about understand how they didn't necessarily come up the first time round. But it's very different to understand how they didn't come up later in response to a lot of specific requests and complaints. While you're on this, over the page, paragraph 7, you'll see the same points I mentioned earlier. It's the way that the process appears to have worked is there were interviews and only 3 were successful at interview. There's no suggestion of any Regulation 18 criteria being considered, paragraph 7. And then, finally, paragraph 11, it's wholly erroneous to state that the defendants callously and surreptitiously promoted Petal Rupnerine. Miss Rupnerine was treated no differently from the other applicants who attended the interview process. So that's the position being adopted at this point. She's not been treated in any way differently. Now, Mr. Smart then replied to this in an affidavit, again on the interim application, of the 4th of April 2014. And we have this, just a few points I want to mention, at bundle 3005. And the first point I want to make is this. He complains at length about the non-disclosure of the other memoranda, that's to say the July and September memoranda, which are referred to in the October memoranda. You can see that at paragraphs 5 to 7. It's a long complaint. And he complains of non-disclosure. Why haven't we got those other documents? Because his case at the moment is he's convinced that Ms. Rupnerine has been given special treatment. And so he's saying, why haven't I got those other documents? What's happened to them? And in paragraph 7, just for your note, he here says that the letter I showed you the 25th of February was, he says, signed by the Chief State Solicitor and read. There's a dispute about signed, but not read. He also complains, my lords, if you go to page 1016, 30.1, another very outright complaint about the non-disclosure of the 20th of September and 25th of July memoranda. So he's, at this point, clearly complaining. What's happened to those documents? Now, my lords, there's no reply to this.
Why does this matter?
Well,
this is 2014. We've had the documents. for a long time.
My lords, our cases, they were withheld on
Oh,
purpose.
so what?
Well, because
It's
that...
bad administration. You've got all sorts of complaints about it. But in terms of what the issue we have to deal with, which is the construction of regulations 14, 15, 18, I don't see where it takes us.
Well, it goes to my second point, that there is material here in which one can say that proper consideration wasn't given to the decision whether to advertise or not. They're embarrassed to, frankly, we say they were embarrassed to disclose that material. That's the proper inference to
But
draw.
was there cross-examination?
No, there wasn't. As I understand it, there was an application to cross-examine, but an indication given by the judge it wouldn't be necessary. But there most certainly were allegations made, in the first instance, that the process was tainted.
Yes, but I mean, you would have had to have cross-examined on that. If you were challenging this evidence, you would have had to cross-examine. And I mean, you may not, the judge may have refused your application, but there it is.
Well, my lords, perhaps I can take the point briefly. We say in any event, reply comes there none to this. Just going back to the chronology, on the 21st of April 2014, Ms. Almarales puts in a Freedom of Information request. This is page 1529, 24th of April, and she asks for recommendations of the Chief State Solicitor to fill the vacant post. And that's not answered, certainly not immediately. But then what I would like to do is just to take you to Miss Pyle O'Brady's affidavit on behalf of the state, or the DPA, at page 1021, in bundle 3. I just want to make 5 points. And they're not just on my presumption of regularity point. Although the first one is, there is no answer. There is no answer in this affidavit to the request for other documents, the 25th of the September and July documents. They're not dealt with. On the contrary, my lords, what one sees at paragraph 14 on 1025 is another wholly erroneous assertion. Let's say the use of the phrase wholly erroneous. Paragraph 14, after saying, talking about where Mr. Smart came in the order, as such, it is wholly erroneous to state, as the claimant does, that the Commission deliberately departed from Regulation 18 so as to facilitate Miss Petal-Roopnarine and her appointed to the office of Senior State Solicitor. This was not a situation of promotion within the service. It's a Regulation 15 appointment. My lords, I do respectfully submit, if you're holding back a document which says on the face of it that was exactly what happened, it's a bit much to put that evidence in. And it does give rise to concern.
Sorry, I understand that.
Well,
they didn't deliberately depart from Regulation 18 because they didn't think it applied.
Well, no, but initially they were. In July 2012, they were going through the Regulation 18 procedure. Yes, that was the point of the original correspondence I took you to. It was
that was the Chief Solicitor who was talking about that.
Yes, but that was what he was writing. What happened was, initially, he was engaged in the Regulation 18 procedure.
But is there any evidence that the Commission ever embarked on a Regulation 14 exercise?
No. Well, we don't know. The answer is, well, there is evidence from which we can draw the inference they might have started but not concluded, because we have the recommendation from the Chief Solicitor, which is manifestly Regulation 18 recommendation to the DPA.
In July, the Chief Solicitor was going down the Regulation 18 road.
Yes.
By September, he was promoting the candidacy of Miss Roopnarine.
Yes.
Yes, that's
and
your
he's
point.
urging an alteration of route.
Yes, and you say paragraph 14 is, in that context, misleading.
That's talking about the Commission,
Yes.
not about the Chief Solicitor.
No, I accept, my lords, it's not the Commission, but on the...
But those two letters were before the Commission.
But they would have been before the Commission. But my lord, I accept you could... I'm just saying this is not exactly what you might call candid evidence.
Yeah, but we're not here judging whether it was candid evidence. We're judging the point of the law.
Yes, well, my lord, I accept that, but my position is that there was a lack of candour here, and it
Now,
does.
what's your third point, Mr. Knox?
But my lords, you have. My lords, the only evidence... now, this is important. What was the evidence about the decision to advertise? And you get that at 1022. 1022, line 5. Now, this appears to be the basis on which the decision, although it's not actually, we don't know much about the decision, you'll see here Ms. Paolo Brady's referring to the 26th of October memorandum. The memorandum stated inter alia that, quote, it was in the best interest of the department that these positions be advertised. So that's what she appears to be relying on. And then you go to paragraph 10, the Commission, at page 24. The Commission has not departed from its prescribed statutory regulatory framework. The Office of Senior State Solicitor was advertised in accordance with Regulation 15, which, when read with the powers of the Commission under the Constitution, gives the Commission the power to appoint attorneys not already within the judicial and legal service to that service. And then I emphasize this in particular. This was being done because the JLSC considered it advantageous and in the best interest of the service to do so, having regard to the matters stated in Regulation 15. Now, my lords, this is exactly, I'll come to the criticism in a moment, this precise formula is used again and again in relation to the other appellants. I'll just give you the references. At 3.1093 paragraph 5 and 3.1095 line 10, paragraph 10, in relation to Almarales in July 2014, and in relation to DAS at 3.1068 paragraph 5 and 3.1170 paragraph 10. So the 1068 para 5 and 1168 para 5 and 1170 para 10. So what you see in paragraphs 5 and 10 in this affidavit are repeated verbatim in those other affidavits. Now, my lords, I submit this is highly unsatisfactory evidence on any footing for the following reasons. First, it just tracks the words of Regulation 15. It's no better than saying, oh, I did everything I ought to have done. And that, in my submission, especially in the circumstances I've outlined, was not good enough. Well, on the face of it, you have conflicting reasons as to what was going on the face of the evidence. Secondly, even on this evidence, there's no suggestion, or express suggestion, that the existing pool of insiders was actually considered. The merits of them were considered. It doesn't say that, except, I suppose, possibly by reference to the words having regard to the matters. But that's not good enough in my submission. Thirdly, and I submit most astonishingly, there's no details of when, by whom, or how this decision was made. There is no, for instance, minute of the meeting. And I took you to the regulations earlier, where I showed you that the DPA has to keep a minute of meetings. There's none exhibited at all.
So was there a request for those minutes?
I'm not sure there was, but my lords, I can't say that there was one. But on the other hand, this is all that came forward
No,
from...
no, but this is May 2014. If you thought it was inadequate, then you would have applied for
yes. Well,
we'd know where we were.
Well, my lords, on the other hand, it is... complaints were made, I should say. I'm going to come to the complaints made about this evidence. But I submit this is manifestly unsatisfactory evidence, even if you leave out the point about the minute. It doesn't tell you anything about how they actually went about considering whether to advertise or not. And all you have is perhaps a suggestion that, at best, there were two things operating on their mind. One is the September letter, and the other is the October letter, or the October letter. You've got those things, but no consideration of the insiders. My lords, the other point I just wanted to emphasise, it's accepted in paragraph 10 and 11 that the regulation process wasn't used. Regulation 18 process wasn't used. The other, I submit, problem with this is that although, if you look at paragraph 20, although, as I said, she denies that the 25th of February letter was signed by the Chief State Solicitor, it's on page 1027, she doesn't deny that he read it. And, my lords, we do add, the other thing that's unsatisfactory about this affidavit is that there are simply no grounds as to how come she knows any of this.
What's the significance of his reading it? Here's
Mr.
Smart going to the Chief State Solicitor. I propose to send this letter.
Yes.
Chief State Solicitor says, well, reads it perhaps, and says, well, you must do what you want to do, Mr. Smart.
Well, yes.
Well, where's that take us?
Well, because that letter says in terms what he had been told by the Chief State Solicitor. So that letter doesn't just say, it's not just a letter complaining, it's a letter complaining which recites the fact, the Chief, I can't remember exactly what it says, but
Didn't know about it.
yes, that the Chief State Solicitor didn't know about the recommendation. But anyway, my Lords, that's what I want to get out of that. My Lords, on the 22nd of May 2014, Mr. Smart puts in yet another affidavit, yet again asking, this is at bundle 3, 1030, and yet again he asks, yet again, there's just a few points. It begins at 1030. At 1032, line 6, paragraph 6 to 8, he complains yet again about the lack of disclosure. But I'd like in particular just to draw your attention to one point he does make at the foot of 1032 in paragraph 7. Notwithstanding the documents are incomplete and don't state the Chief Solicitor's rationale for the recommendation, I verily believe that the defendant's discretion to employ Regulation 15 is not absolute discretion, but one that's limited to the preconditions set out in the said regulation. The obligation is on the defendants to set out all the facts. Now, I emphasise that because from now on, this point was clearly in play. You haven't mentioned anything about the preconditions. And he again repeats the allegation at paragraph 31 on page 24, that there's been a deliberate departure from the Regulation 18 procedure. And he covers again at paragraph 11 what the Chief State Solicitor told him when he showed him the 25th of February 2013 letter. This is paragraph 11. Now, my Lords, there was just no reply to this evidence at all later.
I mean, this is directed to the State Solicitor's doings, which
Yes.
the ladies whose affidavit we saw before wasn't dealing with that. And on the Regulation 14, 15, 18 point, well, they've taken their position, and there's an issue of law which we're hoping to be able to deal with.
Well, my Lords, you have my answer. I do say that you can't divorce the consideration given by the Commission to whether to advertise or not from the information that was being put before them. And indeed, I do submit, if you ask, were all the proper considerations taken into account, looking at all this material, I submit the proper inference would be no. There's been a lack of proper candour by the Commission in explaining itself. And it could have easily put in evidence, and it doesn't put in satisfactory evidence. My Lords, after disclosure of the documents are eventually seen by Mr. Smart on the 30th of July. He puts an affidavit in on the 10th of September 2014, accusing the Commission of rubber stamping.
So the 30th of July was when the documents were
seen. Sorry, 30th of September. 30th of September. Sorry, July, forgive me, July. 30th of July they're seen. And then on the 10th of September, Mr. Smart puts in another affidavit in the light of those documents, expressly accusing the Commission of rubber stamping in the light of the exhortation to advertise to help Miss Routenring get in. And he makes that allegation, bundle 3, page 1062, I think, paragraph 13. And Miss Almarales, likewise, on the 19th of September, puts in an affidavit where she complains, in the light of this material, that proper consideration wasn't given to the insiders. That's at bundle 3, page 1197, paragraph 38. Now, my Lords, there was still no response or explanation from the respondents in the light of those accusations to deal with them, as I submit there had to have been. And absent such, I submit that the court, as Mr. Justice of Appeal Nareen was prepared to do, was to say, well, there are grounds for saying this decision was tainted by improper considerations, that is, the desire to get in Miss Routenring, which meant that proper consideration wasn't given to the existing pool of candidates. That's what it comes to. My Lords, I emphasise that, of course, as my Lord O'Connor says, is maybe not the first point in this case.
It's not because as you told us at the outset, I was anxious to find out what this case was about, and the answer
Yes.
is we want to know how these regulations work for the future.
Yes, my Lord,
Not
that's...
digging around about what did or did not go wrong 7 years ago.
No, but my Lords, it goes to this particular case. I do submit it is of some importance. And my clients, I think, would feel a bit aggrieved if I didn't put this material before you. It is in my submission not ideal and on any footing,
No.
if I can go that far.
No, we can certainly give guidance on what is not the clever way to do things.
My Lords, can I therefore go to the first point, the Regulation 15 point? I'll go first to my submissions. In large part, you've got them. First to my submissions. It's in the bundle of authorities at tab 19. And my submission can be put in fairly simply. Page 1958. And that is, regulations 14 and 15 are talking about the same thing. They're talking about whether you go inside or outside. And Regulation 14 in my submission proceeds on the premise that if it is possible to do so, and in the best interest of the service, you make the appointments from inside. So the default position, if I can call it that, appears to be you go inside. But the Commission, I emphasise, has to form an opinion on that. And it's in the light of 14 that you must read 15, the word considers in 15. Where the Commission considers there's no suitable candidate, or that, having regard to qualifications, it would be advantageous and in the best interest of the particular service, that the service of a person not in the service be secured, they may authorise the advertisement and so forth. Now, my Lords, you have my points. I say the following. First, the Commission must form an opinion, both for the purpose of Regulation 14 and 15. It can't just be something less than that. Second, in forming that opinion, they must do so, quote, having regard to the qualifications, etc., of the existing insiders. And what I say about this, I'll come to the Court of Appeal's judgment in a moment, is there's no evidence of any opinion as such being formed. That is because the evidence simply tried to track the wording of Regulation 14. And my submission, in a sense, that the respondents are hoisting their own petard. They've tried to just follow the wording, but they haven't actually, because they've given such short shrift at this point, they haven't actually said whether an opinion was formed or not. And secondly, there is no evidence at all that of any consideration being given to the insiders as part of the process. So I submit, even if one looked at, if this was a matter without the judgments below, I would say this was plainly not a proper decision because the preconditions hadn't been satisfied. My Lords, can I deal first with the judgment of first instance? And that's at Bundle 1, 482, page 33.
Sorry, Bundle 1, page...
Bundle 1, page 482, paragraph 33.
Thank you.
Well, I say 33, really, it begins at 31. Page 481. She says, here, the Commission does not have to be satisfied or be of the opinion, I emphasise that either A or B applies, but merely has to consider that one or other applies. The word consider suggests to me a much lower threshold of conviction. Regulation 15 does not treat with the word appoint or appointment. What it does require is advertisement, thereby suggesting the need for a decision taken from among all the persons or candidates who have applied for the post. In such an exercise, it would seem to me that eligibility of an officer for promotion is irrelevant. And she then goes on to discuss paragraphs 32 and 33, how the regulations interrelate. You can pick it up again at 33. In the circumstances, I'm satisfied that Regulation 15 is a standalone regulation, the application of which does not require the Commission to apply the Regulation 18 criteria. My Lords, I would agree with that if you're just dealing with outsiders. An advertisement pursuant to Regulation 15, in my opinion, renders the application of Regulation 18 odious. Indeed, to apply Regulation 18 to a Regulation 15 advertisement, in my view, would defeat the purpose of the regulation. The Commission would be bound to take into consideration the criteria to the detriment of the very persons whom the regulation wishes to attract. So, in other words, if you want to get in outsiders, in a sense, bad luck for the insiders, if they join in the same competition. And then she goes over in regulation, paragraph 34, to apply Regulation 18 in such a situation as this could not have been the intention of the legislation. It seemed to me the purpose is to allow the Commission to attract a different type of person than one found suitable using the Regulation 18 criteria. I was pausing there. Absolutely agreed. Of course that's right. In the circumstance, I am of the opinion that Regulation 18 does not apply to appointments made pursuant to an advertisement under Regulation 15, to which we say, agreed, but if you've got insiders, the insiders must be determined in accordance with Regulation 18 criteria. That's essentially what we say went wrong with her judgment, but the important point, just while I'm on Regulation 15, is she says that the word considers is a lower threshold. And there is no finding by her, nor, I submit, could there be one, that the Commission had formed an opinion, bearing in mind the inside pool as to what to do. My Lords, the Court of Appeal's decision is in Bundle 2 at 796. One can pick it up at paragraph 28. See how they put it after setting out the two separate conditions. About 7 lines down, the sentence beginning, in this case. In this case, a precedent condition for the Commission's exercise of its powers under Regulation 15 existed under the second independently existing limb, when it considered it advantageous in the best interest to secure the service of a person not already in the service. The Commission went on to take necessary steps to ensure compliance and so on. The placement of Regulation 15 in the scheme of regulations and its contents substantiate that this is to be regarded as a standalone provision. We agree with the reasoning of the judge. The use of the words where the Commission underlined considers, in our opinion, does nothing more than confer a discretion on the Commission to decide whether it should authorise the advertisement of a vacancy. This wording further suggests that what is contemplated is not a definitive evaluation of officers who are within the service, such as would lead to a threshold conclusion that those officers are not suitable, even before the decision to advertise occurs. Rather, the language of Regulation 15, in particular the second limb, suggests the need for a broader, more panoramic type of evaluation by allowing for the expansion of the pool of candidates consistent with the intention of Parliament. In this respect, we respectfully disagree with the judgment of Mr. Justice of Appeal Nareen. In our judgment, and in disagreement with Mr. Maharaj and Ms. Masdio, there's no requirement for a threshold determination of unsuitability as a condition precedent. My Lord, that in my submission was a misunderstanding of what was being submitted. What was submitted was you have to consider the officers. And they go on to say we don't therefore agree with Mr. Justice of Appeal Nareen. Now, if I can just take you to Mr. Justice of Appeal Nareen's judgment on this point, and that is at page 83, I think it starts at 839. At paragraph 49, begins at the context is paragraph 48. And Mr. Justice of Appeal Nareen refers to a submission made by Mr. Maharaj that first of all you've got to consider the first limb of Regulation 15 before you go to the second, And a reference is made to a Trinidadian decision, Winston Gibson, a judgment of the Chief Justice. The process of selection and appointment begins with a consideration with whether it's possible and in the best interest of the particular service and so on. Then he continues, in my view, this approach is consistent with logic and good sense. The officers within the particular service are more likely to be conversant with the practices and procedures employed within that service and the duties to be filled than persons entirely new to it. Further, if the Commission has not made some kind of assessment of the qualifications, experience and merit of persons within the service, on what basis can it conclude that it would be advantageous in the best interest of the service to fill the vacancy from outside? And then we adopt that reasoning. We say, quite right, there has to be consideration of the qualities of the insiders, full stop. And then...
But does that consideration go to the extent of deciding that the insiders weren't of suitable quality?
No, you don't have to go that far. You might say, my lords, for instance, you might say, I think we've got some pretty good people here, and we need to, you might well say, they're obviously good enough. So let's move to limb 2. You then look at limb 2 and think, well, they're good enough, but on the other hand, I really think we need someone different for the sort of jobs we are now going to be having to do for the next 5 years or whatever. So you do have to consider the qualities of the existing staff. If they're just no good, well, then it's easy. You advertise. But if, in fact, they are good enough, you still have to consider how good they are before deciding whether to go outside.
But if you decide on limb 1 that they're not good enough and you advertise, yes, they can apply for the job?
Well, no. There wouldn't be much point. In my submission, no. In my submission, because you're going outside.
Because they don't know at that point why, which limb has been decided. So they're not debarred from applying, are they?
Well, they wouldn't necessarily, my lord, my lady, I can't say they would be debarred from applying, but the advertisement would go to the outside world. And in my submission, the logic of this position is if you've decided it's not in the best interest of the service to recruit from outside, it's difficult to see how, in practice, if an insider does apply, pursuant to the outside advertisement, how he or she is going to get anywhere. Because the decision has been made to go to the outside world.
Well, that's why I was asking the question. Does your submission not assume that before you get to B, you have to conclude that there is no suitable candidate? And in that case, are you facing up to the fact that Regulation 15 is worded either or?
Well, my lords, no. I submit it's either or, because I don't submit that there has to be a conclusion that. Well, my first submission is this. It's even if you consider there are people who are suitable, you could go under the second limb and say, well, I think there are, having considered the current crop, there are people who are suitable. But on the other hand, I think there are special circumstances here which would make it desirable to get someone even better. That's what it comes to. That's my first submission.
You're not suggesting that you can rule out the internal candidates and putting their hat in the ring and seeking to show at interview that they're actually much better than your first guess?
Well, my lords, if they were then to apply, my lords, on the face of it, the logic of saying I want to go outside is that you've decided that it's in the best interest of the service to advertise outside, and therefore, by implication, to recruit from the outside.
Well, you've made a preliminary judgment of that, but surely not a final decision.
Mr. Knox, are you then saying that it was unlawful for the Commission to make its internal advertisement?
No. No, not necessarily, my lords, but you could... The whole problem in this case arises because you've got two vacancies. Now, one possibility would have been for the Commission to decide we want to get 2 people from the outside. It's in the best interest of the service to get 2 people from the outside. And my lord, can I just go to Regulation 15 again? Because what the decision is under Regulation 15, we have to make a decision. You have to, I say, be of the opinion that it would be in the best interest of the particular service that the service of a person not already in the service, the Commission may authorise, the service of a person not already in that service be secured. The whole point of going outside is to get is to secure the services of an outsider. So on the face of it, if that's your decision, it would be inconsistent with that decision to say, well, I'm still going to recruit from the inside. But, my lords, I don't say it's impossible that you could do so. I just say on the face of it, it's rather peculiar to do so.
Well, appointment is a relative concept. You judge the merits against each applicant's own merits in a relative way.
Yes.
But the trouble with the way you're approaching it is that this is an elimination process, because you prefer to concentrate on limb 2, but if you concentrate on limb 1 of Regulation 15, you've said there's nobody suitable. And on your analysis, you've done so definitively.
Yes. Well, in this case, no consideration at all has been given as part of the problem.
But I'm looking at the legal question that underlies this, which has to work not just on these facts, but on other facts as well.
Well, in my submission, if you decide that there's no one suitable, that's easy enough. You then go outside.
And they can't apply, the others can't apply then?
Well, my lady, whether they can or can't, it would seem on the logic of going outside would be you form the opinion that we need to get an outsider in. If you form that opinion, it's a little bit odd to allow insiders to come into that competition.
But it will often be the case, Mr. Knox, that you won't know about the likely applicants from outside, and there may be people inside who could do the job, but you may form the opinion under Limb 2 that it would be better to advertise this and see what we can attract.
Yes.
And in those circumstances, where are you left so far as the internal candidates are concerned?
Well, my lords, if you do that, then my submission is the internal candidates can apply, but the competition as between the internal candidates must be assessed by reference to Regulation 18.
Now, Mr. Knox, you've got less than half an hour, and of course, Mr. Pennington-Benton is going to be addressing us.
Yes.
How are you getting on?
Oh, fine, absolutely fine, my lords.
Good.
Fine.
Well, could I ask this question?
Yes.
I mean, let's test Regulation 15 by the circumstances that occurred here, but taking out of it your understandable complaints about lack of candour. Let's say everyone was told Miss Ruth Marine has been in this service for 6 years, she's got 10 years outside experience, she's a valuable asset and may be suitable for this post. In those circumstances, we consider it fair that she, as well as insiders, i.e. people who were formerly of the staff, should be allowed to apply for the job. Would that be an objectionable thing to do?
My lords, no. I think I'm bound to accept that the strict logic of my position is, and I accept it's a bit too strict, is that if once you decide to go outside, you've got to say to all the insiders who say, oh, I'd like that job, you've got to say, no, you're out. I'm not going to consider you. My lords, that would be one possibility. But the other possibility is you'd say, well, I will consider you. And my lords, I say that's an alternative construction. I will consider the insiders. The question then is, by what criteria are the insiders to be assessed?
Well, I mean, that's Reg 18, but the Reg 17, if as in this circumstances, you had someone who was reckoned to be able and you wanted to widen the pool from the insider to enable her to throw her hat in the ring, as it were.
Yes.
You don't say that Regulation 15 excludes that.
No, my lords, I think I'm driven to say that it doesn't actually exclude it. No.
But you say the way it's been gone about doesn't show that that's what they've done. Is that what
yes,
you're saying?
that's what it comes to, on the facts of this case. So, my lords, as it were, if you're asking me what you might call the point of law detached from the particular facts of this case, then, my lords, I think I'd be driven to accept that once you've decided, even if you've decided, having regard to qualifications and so on, that it's in the best interest to advertise outside, you'd still be entitled to look at people from the inside. If I can, for the common sense reason, you might not get anyone who's much cop from the outside, or the other reason might be one or two of the insiders might turn out to be absolute geniuses. They just hadn't been discovered yet.
Yes.
But so, my lord, I don't take what you might call an absolute position on this, but I do submit I'll come to Regulation 18 in a second. I do submit, my fundamental point is you do have to have regard to the qualifications, experience and so forth, whichever limb you operate under. And secondly, you have to form an opinion. It's not good enough just to say, well, I consider, not really to consider the point properly. So you have my position on the facts of this case. And I do say, with respect, the judgment of Mr. Justice of Appeal Marine, I've taken to one paragraph, but at 61 to 63 at page 843 is the correct approach, page 843, and again at 69. My Lords, can I just mention, I know at the moment I haven't got too far on the presumption of responsibility, can I just mention the following points, why I say it's inappropriate. First of all, I submit once leave has been granted, it is inappropriate to resort to the presumption of irregularity. The whole premise of leave is there's something to be looked at. And particularly, my Lords, there's the case of, well-known case of Huddleston and the authorities, tab 9 at 1784.
That just says you have to put the cards on the table, face up.
Sorry?
The authority has to put their cards on the table, face up.
But also, interestingly, it's got other bits which are quite useful about you can't just put in blanket evidence and things like that. There's no use just saying, oh, I considered all relevant factors.
Yeah, but you have to you deal with the points that are being made against you.
Yeah, you deal with the points made against you, and also you don't just put in what I have called, in this case, conclusory evidence. You can't just say, I considered everything I had to. And it makes both those points. It's at tab 9. And I won't invite you to look at it because I'm conscious of the time, but if I can just give you the reference, it's 1784 in the judgment of Sir John Donaldson, second paragraph going over the page to 1785, but also Lord Justice Parker's judgment, which is not so often referred to, at 1785, foot of the page to 1786. There's also a decision of the local court of appeal, a judgment of Mr. Justice of Appeal Jamadar, which is at page 1685, and the authorities at paragraph 19, where he essentially makes the same point. But the idea being, once leave has been granted, you can't just say, you can't resort to the presumption of responsibility. So I said, that's what, sorry.
I can see, if you write as your defence something taken out of Wade on administrative law, just saying we did this and ticked all the boxes,
Yeah.
And then you say, and we can rely on the presumption of responsibility, that certainly doesn't meet the cards on the table criterion.
Exactly, so it's quite inconsistent. So that's the first thing we say. And so therefore, to the extent it matters in this case, and the Court of Appeal did think it matters as a backup at least, I say it's impossible. Secondly, we say you cannot rely on the presumption of regularity
Yes.
to make good hopeless evidence. And I submit in this case, for the reasons I've given, the evidence about the consideration of the relevant factors in Regulation 15 is hopeless. Just track the words. You can't then say, oh, well, you can presume it's all right. And thirdly, I do submit in a case such as this, where there is positive evidence of at least some attempt by the Chief Solicitor improperly to influence the outcome, again, you can't rely on the presumption of regularity. My Lords, I can deal with my second point argument quickly, and I should say it's entirely self-standing, and I don't need to run it. If I'm right on my first point in relation to Regulation 15, that is, the decision was tainted. And what I say in summary is that the decision of Mr. Justice of Appeal Narayan was correct, and you have our submissions at paragraphs 82 to 88 of our written case at page 15 and 17. The way I put it is this. First of all, the Chief State Solicitor's Act in writing that letter was improper, for the reasons I've summarised.
Was what?
Was improper.
Improper.
He's entitled to make a recommendation to the DPA. What he's not entitled to do is to try to get the Attorney General to lean on the Chief Justice. And he's not entitled to make exhortations, which is what he did. He's limited, and this is an important point for the future, my Lords, I submit, he's limited by Regulation 13.1 as to what he can do. Secondly, I do submit that one can properly draw the inference that proper consideration to the relevant factors was not given by the Commission to the decision to advertise. And if I can just say why I say that, just summarise the points. I've already briefly mentioned them in passing. First, there was an unexplained failure to disclose timeously the July 2012 letters and September 2012 letters, completely unexplained, despite requests, repeated requests. And on the contrary, what there was were protestations that it was quite wrong to say that the Regulation 18 process has been departed from just to facilitate Root-Noreen's appointment. Well, I submit that was untrue, or at least not candid. Secondly, there was a mass of evidence which, in my submission, contradicted, or rather put in question, what the real reason for the decision to advertise was. You have, on the one hand, the Permanent Secretary's memo, which says we've got a shortage of staff and so on, of the 26th of October. Fine, okay, on that, so fine. But on the other hand, you have the Root-Noreen letters from the Chief State Solicitor. You have the 23rd of February 2013 letter, which was from Mr. Smart, which he says, and uncontradicted, seen by the Chief State Solicitor, saying the Chief State Solicitor didn't know what was happening. And you also have evidence, Bundle 3, 1355, paragraph 12, where Mr. Smart says he spoke to the Chief State Solicitor after getting one of the affidavits, where he said, according to him, according to Mr. Smart, the Chief State Solicitor said, well, he did what he did because he'd been bombarded by Miss Root-Noreen. And that's why he tried to get her in. Now, that was just uncontradicted. So I submit there was quite a lot of evidence which put in question as to what the real reason was, A, for the Chief Solicitor to write his letter, and B, what considerations the Commission took into account, bearing in mind they appear to be acting on the Chief State Solicitor's correspondence. Thirdly, I say there was a failure to deal in the evidence at all, even after Mr. Smart and Miss Almarales had made complaints based on the undisclosed documents of rubber stamping. There was no reply to that. And perhaps most importantly, there was simply no evidence really as to how the decision was made to advertise. We just have various memoranda, and I submit a wholly unsatisfactory affidavit which just tracks the wording of the rule. My Lords, that leaves the Regulation 18 point. I can deal with that quickly. My Lords, it's clear that the Regulation 18 was not applied at all. I've given you the references, but once again, Bundle 4, 1467, and also the affidavit of Miss Marcia Pyle-O'Brady in the supplementary bundle, which I showed you earlier. I submit that, in a sense we've already gone round this argument, but I submit that on a proper construction, Regulation 18, if you just go to Regulation 18, is mandatory. Tab 19.
Yes, we've got it.
In considering the eligibility of officers for promotion, the Commission shall take into account, and so on. And likewise, Sub-Regulation 3 at 1959, in the performance of its functions under 1 and 2, the Commission shall take into account. Now, my Lords, these are mandatory words. The clear purpose is to ensure that important things like overall evaluations over the years are taken into account. And in my submission, you cannot just depart from this as between the insiders. And this provision would be, the force of this provision would be seriously diminished if it were the case that, as in this case, you could advertise the outside world, get 2 outsiders applying, 9 insiders applying, and the insiders don't have the protection of these regulations or the advantage of them, as between themselves. And I say, therefore, for that reason too, the decision was fundamentally flawed. My Lords, I think I mentioned to Mr. Benton that I would give him 10 minutes. So I just pray, just deal very briefly for the next 5 minutes with the other points. A point is taken against us, which is a just point by my learned friends, that we don't take the Regulation 18 point in our notice of appeal to the Privy Council, which is true. In fact, we had taken it below, and we had also taken it in our application for leave to appeal, and it's also in the SFI as a point. But we understand that the respondents accept that if we amend our notice of appeal to include the Regulation 18 point, then it all goes. And my lords, there are suggestions.
Your point of law.
Your point.
I've not insisted on any amendment.
Oh.
What we've indicated is that we don't take any objection to the point being argued.
It's clearly a point which we ought to consider.
I'm sorry to misrepresent. I misunderstood in that case an email that came through to me. My fault, not from Mr. Stevens.
The gate is open.
There are, and can I just say this? We do accept that in certain respects the shape of the case has changed over the course of events. But we do say, in essence, and I'll reply on this if it's of any significance, that it was the points we make now in relation to Regulation 15 about the non-advertisement, the presumption of regularity and the tainting and so on were clearly put to both courts below. As far as the Regulation 18 point goes, I accept it wasn't put in quite the way we put it now, namely that you have to, whatever else happens, you have to apply it as between the insiders. I accept it wasn't put quite that way, but again, it's a pure point of law as to how Regulation 18 should work. My lords, finally, just briefly, the question of relief. I accept we haven't claimed damages, and my clients don't claim damages. We would have to have mentioned that. But we do say it is of importance that declarations are given and rulings of law are given, but also the declarations we seek are those at the, I think, near the end of our written case, which, my lords, just for your note, what we say is at page 1521, paragraph 96. And we summarise the position there as to what we say the declaration should be.
And the decisions, you're talking about the decisions of the Commission.
Yes, of course, my lord, yes, but I should have made that plain, but yes.
All right, thank you.
My lords, I think that deals with it. There's one point, Mr. Strang, when I was just mentioned a moment ago, which we say is fundamental to this case, and since it's right at the heart of it, and we say Regulation 18 is mandatory, as between insiders, and a lot follows from that, both in relation to Regulation 18 itself, but also in relation to Regulation 15, at least in part. My lords, those are my submissions.
Thank you very much. Mr. Strang, do you follow? Mr. Pennington-Benton.
Very much. Well, my lords, I'll be very brief because I do respectfully, unsurprisingly, is that my bundle? Thank you very much. Adopt the submissions of Mr. Knox QC. He has very carefully and helpfully set out much of Mr. Smart's evidence, including the requests for the further documents, which belatedly came forward in 2014 following his persistent requests and freedom of information requests. I will just mention one or 2 points of his evidence, if I may, but firstly, just dealing with the Regulation 14 point for completeness.
Can I be as clear that there was no application made for cross-examination, at least no application pursued for cross-examination?
Well, there is an application that appears in the...
I know there's an application, but as far as I understand, it
proceedings.
wasn't pressed, apparently because of an indication from the trial judge, so Mr. Knox.
As an indication, I believe it just wasn't pressed after that. That's all right.
It certainly wasn't pursued. I've not seen any reference to it being as a result of an indication by the trial judge.
Yeah.
But what I have seen is an indication that the parties informed the court that neither party sought to pursue cross-examination.
I see. Thank you.
Thank you. But just for your references, Volume 1, page 60.
Volume 1, page?
60.
Thank you.
So this is the statement of issues filed pursuant to the order of Justice Jones. Issues 6 and 7 raise squarely the question of whether the facts existed at the material time to give the defendants the authority to use Regulation 15. And then at 7, was the defendant's decision to use Regulation 15 to fill the 2 vacant non-entry level positions, etc., whilst there were suitable and eligible officers already within the service. That was an issue that was fairly raised in the pleadings, and it was obviously something that was grappled with by the judge by the time it came to trial. Can I briefly turn to Volume 4, just to flag up 1 or 2 parts of Mr. Smart's evidence. His first affidavit, please. This is at page 970. Oh, sorry, Volume 3. Volume 3, 970, thank you. Of course, certain points were said about the hierarchy, as it were, or the desirability of the other appellants vis-à-vis my client for the position of senior state solicitor. There's obviously 2 vacant positions, but what he does here at paragraphs 28 to 31 is to set out his history of employment within the service, having been appointed as a chief state solicitor 1 in 2007, and then at page 30, paragraph 30, acting in the post of State Solicitor 2 for the following periods, and then finally in 2011 promoted full-time to the post of State Solicitor 2. And then at paragraph 32, over onto the page, he sets out periods during which he acted in the position of Senior State Solicitor, and indeed his evidence was that he was acting as a Senior State Solicitor at the time of the recruitment campaign in 2013. So he would have been, in my respectful submission, well placed, given that the Commission had obviously already formed the view that he was good enough to perform the role.
Yes.
For not just 1, but for 6 periods, including twice after people were appointed over his head in 2013. So I just say that for the purposes of clarifying his position, because
Thank you.
He wouldn't like to it to be gone unchallenged that he was somehow down the bottom of the pecking order. Quite
yes,
the reverse.
we've noticed that. Thank you very much.
Quite the reverse. So I realise it's not a massive point, but it's an important point for my client. But
Yeah, what's the next one, Mr. Pennington?
thank you very much. Yes, the next point is about relief, because Mr. Smart did include a claim for damages. I'll just give you the reference, volume 1, 14. He was granted permission to amend to include a claim for damages. Second reference, volume 1, page 112. This was the claimant's submissions at first. I don't necessarily need you to turn them up unless you're eager to, but basically he made submissions about being entitled to damages, albeit I accept on the basis of misfeasance. Which, depending on what the board finds in relation to the letters and so on, may be a tool.
But damages against whom?
Against the Commission for effectively...
But I mean, there's no suggestion is that they are guilty of misfeasance. There's something about the chief solicitor.
Well, I think...
I mean, are you asking us to make an award of damages for misfeasance by the Commission?
No, I mean, it would be a matter that would be remitted, if at all, to that.
No, but is that in your, is that in your case? I can't remember.
It simply flagged up the fact that there was a claim for damages.
Yes, but before us.
Well,
Yes, in paragraph
yes.
26, your case
Yes.
said that you sought damages
Yes.
before the board.
Yes.
Yes, very well.
Yep.
So,
It also
and-
said you're not pursuing legitimate expectation. That is noted. You're not presumably pursuing ground 6 of your grounds of appeal about bad faith, are you, Mr. Pennington Benton?
Well, it rather depends on the findings. I mean, I think both appellants have invited the board in their submissions to infer that the Commission deliberately withheld the late disclosed evidence that was only extracted by way of the Freedom of Information request. And if that's right, then there is bad faith. But
not bad faith in the decision of the Commission to make the appointments.
It would be later conduct, but effectively concealing the fact that
Well, we
the
need to be
criteria...
clear what you're submitting. If you're making a case of misfeasance, claiming damages based on misfeasance, we need to know what the operative misfeasance is.
Well, it would be having been impermissibly influenced by the letters of July 2012 and September, 20th September 2000.
I mean, how can you do that without having cross-examined anyone?
Well, that's why I say, I mean, that's our submissions, those are my instructions. I understand, obviously, that has been discussed.
Would there not be a further difficulty in any event that if you go back to July, 2 names were put forward by the Chief State Solicitor as suitable people, and Mr. Smart wasn't one of those names? So how are we to infer on the balance of probability that if there hadn't been what you claim was misfeasance, Mr. Smart would have been the appointee? So I mean, you need to establish that he has lost out in order to claim damages. At the moment, I don't think there's evidence that would let us do so.
Well, if the Commission didn't turn its mind to the requirements of Regulation 15 before advertising out, then it was wrong for it to advertise out. If it didn't advertise out, that leaves 2 vacancies to be filled by 4 people. So the fact that 2 people were, I mean, he still stands a chance, doesn't he? And he's entitled.
Well, that's what I mean. We would then be down to valuing a chance. And where's the evidence that would let us even begin that exercise?
Yes, what's the next point, Mr. Pennington-Benton?
I think that's it. Yeah.
Well, the board's very grateful to you.
Thank you.
Thank you. Very well, Mr. Stevens.
Can I just deal with the cross-examination point, because otherwise I'll forget to give you the relevant references. In volume 1, at page 34, is part of an application that starts on page 32, in paragraph 10 of which, on page 34, you see that the claimant sought leave to cross-examine Marcia Piles O'Brady on her affidavits, and specifically in relation to various parts of those affidavits. Interestingly, I interposed not paragraph 10, about which Mr. Knox complains on the basis that she didn't say anything by way of amplification of the reasons for proceeding under Regulation 15, but there it is. Page 225 of the same bundle, which are some written submissions put in by Miss Almarales. At paragraph 18 at the top, it indicates that on the 8th of December at a pre-trial review, the parties, through their respective attorneys at law, informed the court that they did not wish to cross-examine the parties. That was what I had seen, but couldn't remember exactly what it was. And apart from that, if one then goes back to page 63, finally, we find what I think must be the order made at that pre-trial review. And you'll see that it's silent as to cross-examination. Sorry, my lord, page 63. I think I can be reasonably confident in saying that is the order made at the pre-trial review. It simply doesn't mention cross-examination. So no order was made, apparently, because the parties said they weren't pursuing cross-examination.
Nothing. I mean, can I just, on that point,
yes, my
so you can perhaps consider it over lunch, the Huddleston case, which we were referred to, yes. If you go to the volume of authorities, tab 9 at page 1786,
yes, my lord.
You get Lord Justice Parker dealing in some detail with what one does
yes.
if there's a complaint of lack of
yes.
full details, and he explains that the answer will depend very much on the circumstances. You may just say, this is at 1786b, the authority may just say, we admit it was not taken into account, but it was not relevant,
yes.
which I think is what your position is on Regulation 18. But they then go on to say, circuits which they have to do further, and at D, they can say it's for the divisional court to decide in each case whether it's adequate and what to do about it.
Yes.
And they can order discovery or interrogatories or cross-examination and so on.
Yes.
Now, is that the approach which is, we were referred to one Trinidad authority, I think, but is there any reason to require a different approach in Trinidad to what's suggested there?
I don't believe so, but can I reserve my position and try and assist you on that after the...
But it's just that I think if we may need to say something about this, because a great deal is made here of the lack of candour in the affidavits. But as far as I can see, nothing was actually done about it at the time, or not pursued.
My lord, that is certainly right. As to what may be the practice in Trinidad and Tobago, I am a little hesitant without just taking further instructions.
Yes, very well.
Right, except the case we were referred to, which I think was Graham, they seem to base themselves on Huddleston.
Yes. Oh, there's no doubt that Huddleston, in other cases also, is referred to in the Caribbean. There is absolutely no doubt about that. As to the practice as regards interrogatories and disclosure in such cases, I'm a little more hesitant, but perhaps
I don't know what the practice. I'm just saying that whether we should be taking, what we should do about allegations of impropriety or lack of candour in circumstances where nothing has been done about it at the time. Well, I'd like to know what your submission is about this. But perhaps after.
My lords, in due course, I'll be saying something about the allegations of lack of candour.
Yes, but I'm more interested.
Assuming, for present purposes, that there is such a problem, then your lordships are interested in knowing what should be done about it.
I am, anyway.
I completely understand. And can I not answer the question now, my lord?
No, but after lunch.
But after lunch. Thank you. Now, my lords, can I just start by outlining my submissions under 4 heads. My first submission I can summarise as follows. On a proper construction of Regulation 15, it was open to the Commission, if it considered it advantageous and in the best interest of the service, to authorise advertisement without first conducting any form of assessment of internal candidates. Secondly, my lords, moving now to the candour aspect of Mr. Knox's case, this is not a case, in my submission, in which there is no evidence about the relevant decision. And by that I mean the decision to authorise advertisement under Regulation 15. But, to the extent that the appellants complain about a lack of detail as to the reason, or I suppose reasons, for the decision, there can, in my submission, be no valid criticism, bearing in mind the way the claims were advanced. And, therefore, it does not follow that any adverse inference should be drawn and or that the decision was irrational or not based on proper considerations. Third, the Commission's decision to authorise advertisement was not rendered unlawful by the Chief State Solicitor's letter of the 20th of September 2012 to the Attorney General, copied to the DPA, or the failure to disclose it. Fourthly and finally, if advertisement is authorised pursuant to Regulation 15, the ensuing recruitment process does not require the assessment of internal applicants by reference to the Regulation 18 criteria. Now, my lords, I'm going to start with the first, so the question of construction. To remind your lordships, you have the regulation at tab 19, and you find 14 and 15 at page 1958. Now, my lords, I start with Regulation 15. Regulation 15 gives the Commission the power to authorise advertisement in two different situations. It's my submission that the second situation, the one relied on by the Commission, that having regard to qualifications, experience and merit, it would be advantageous in the best interest of the particular service that the services of a person not already in the service be secured, does not require, as I've already indicated, any assessment of the suitability of candidates already in the service. Now, I submit that that is clear from a plain and ordinary reading of the provision itself, and in particular, the disjunctive either or formulation which has been employed by the draftsman. So, as I've said, the second limb, given that alternative disjunctive formulation, provides for different and alternative situations. Now, the disjunctive formulation was, I submit, plainly deliberate, and not only is it clear from the use of the words either or, but equally if you contrast it with the conjunctive formulation which has been used in Regulation 14, where it has to be both possible and in the best interest of the particular service. And that different formulation in 15, what I've referred to as a disjunctive formulation, has therefore to be given some meaning.
How can the Commission consider that it would be advantageous and in the best interest of the service that the services of a person not already in the service be secured before it assesses the quality of anybody outside the service who might apply?
There could be a number of explanations for that. The most obvious, perhaps, is that there could be an advantage or a benefit because, for example, the particular attributes of the identified potential external candidate would, of themselves, add value or bring something additional, something worthwhile to the service.
I think Mr. Knox accepted that on the hypothesis I put to him, that assuming, setting aside all the other criticisms, if everyone had openly said, Ms. Ruth Marine has worked for us for 6 years, she's 10 years commercial experience, she is someone that we would like to have as a candidate in a competition, that would be sufficient, you say? Yes.
I mean, I would have expected this to read, where the Commission considers that it would be advantageous best interest, to see whether the services of a person not already in that service be secured.
Well, my lord, this is only about authorising advertisement. It doesn't compel, as a result of that process, the recruitment of an external applicant.
No, very well.
Yes, so you say, notwithstanding the wording, it might well be that you have a competition where you have outsiders and insiders, and the insiders win.
Well, my lord, yes, because...
But there has to be a trigger which has led the Commission to think that there would be an advantage either in having a particular person who's been identified in the competition or persons with particular skills.
Now, I readily accept that in some instances that process might involve, as my Lord Wilson put to me, some sort of consideration of the people you've got, but it wouldn't necessarily do so.
Right.
And the example that my Lord Hodge put to me was such an example.
In the second limb, qualifications, experience and merit seem to be floating, they're not actually attached.
Yes, no, they're difficult. And my submission would be that the one thing they don't mean is what Mr. Knox wants them to mean, namely the qualifications, experience and merit of insiders, of people already in the service, because it would have been very easy to make that entirely clear. What in my submission they mean, or must mean, or refer to, are not the attributes of internal candidates, but qualifications, experience and merit, and by merit it must mean the ability and competence required for the post in question. Alternatively, and I hazard this tentatively, the reference could be to qualifications, experience and merit of a potential external candidate who has come to the attention of the Commission.
Well, that's really the point I put
And
to
that is
Mr.
the point
Knox.
you put to me, exactly.
And I put to you, and he accepted that,
Yes,
that,
he
that
did.
it was possible that could...
I don't think he did so in the context of what those words meant, my Lord. I think he accepted generally that there could
Yes,
be such a situation, in fairness to him.
Yes, yes,
I think he agrees with me.
you are particularising his concern.
I am particularising his concern. My Lord, I mean, it could mean that second alternative, and it could be a provision that essentially requires, in such an instance, there to be a competition as a matter of fairness. But my primary submission is that it refers not to any particular person's attributes, but to those required or appropriate to the post.
Now,
I'm sorry.
both the trial judge and the Court of Appeal agree with Mr. Knox's construction, don't they?
I'm not sure that they do.
Don't they? Well, we'll have to look at it.
They didn't agree with my construction of considers.
No, we're talking about qualifications, experience and merit. Whose qualifications? Whose experience?
I'm so
whose
sorry.
merit?
I'm so sorry.
And I thought that both courts below agreed with Mr. Knox that this is talking about the insiders.
Lord, I'm not entirely sure that's right. I'll visit that if I'm
Very well.
short adjournment. Forgive me, I thought your Lordship was speaking more generally of Mr. Knox's
I didn't mean
construction.
to, no.
No. I'm relieved that I hadn't missed that in the judgment of the Court of Appeal.
Yes?
Now, my Lord, just picking up where I was a moment ago, in relation to this disjunctive formulation, not only in my submission is the evaluation under the second limb of Regulation 15 not dependent on whether there is or may be a suitable candidate in the service, in the sense that that person could do the job, but the regulation proceeds on the basis that there may be a suitable person, but nevertheless it would be advantageous and in the best interests of the service to authorise advertisement. That is the plain reading of the disjunctive formulation. Now there's a suggestion, well, I've seen the time. And
Is that convenient for you?
It's as good a
Mr.
time
Stevens?
as any, my Lord. So,
Well, then it's convenient for us.
my Lord, I'm grateful.
So we'll consider this case again at 2 o'clock.